Okay.
Good afternoon. May it please the court. Attorney Tooten from Memphis, Tennessee. I'd request 3 minutes rebuttal.
3 minutes. All right, sir, you may proceed.
Yes. This case is very straightforward. I will jump right into it. I'll first address the issues that was raised in the motion to dismiss about whether or not there is an issue still for this court to consider. Because on this matter, there was an issue regarding a traffic citation or a violation of the Tennessee Code annotated as it related to the handheld device. And it is no dispute that there's now an order entered in the trial court dismissing the matter. But I wanted to be clear going to the response to the motion to dismiss that it is still properly before this court for multiple reasons, which I'll go into. But one of those reasons is when you have an issue of great public importance or affects the administration of justice. Another is when the challenged conduct is capable of repetition and is of such a short duration that it will evade judicial review.
Mr. Tooten,
yes.
Is this a declaratory judgment action, or is this an appeal of your conviction to a Class C misdemeanor?
It is an appeal of a conviction of a Class C misdemeanor.
So what is a matter of immense public importance have to do with what we're doing today?
Yeah, so addressing that question, dealing with the handheld device issue and whether or not the city of Covington in that court has any jurisdiction to even be handling these cases, I think based from the record, even based from opposing counsel's responses, it is clear that it has no jurisdiction. So what we have, going to your concern and your question about public importance, we have people's property rights, specifically their driver's license and their ability to drive. You have a court that is impacting people's driver's license. In my case, they suspended it.
So what is the proof in the record that we have a municipality impacting people's driver's license, and that we should, in your appeal of a criminal case, address that at all?
So first, it goes to whether or not, and that's a good point, a criminal case, whether or not the city of Covington has any subject matters jurisdiction, because in the record it specifically states, and I cited to it on my citation or ticket, that your failure to appear—
Mr. Tooten, I hate to cut you off again, but is that an issue in this appeal?
Yes. I'm sorry.
And how is it framed as an issue in this appeal?
So whether or not they have jurisdiction impacts everybody. Because if you're able to, so let's say we're starting with the understanding that they have no jurisdiction, the city of Covington, and then someone gets pulled over for this handheld device, which we say they have no jurisdiction over, and they don't appear to court. They are subject to a separate criminal prosecution and or fine is how they've termed the language. So it's not just me who was subjected to that conduct. Anybody who is traveling in the city of Covington is subjected to that. But to go further, to go to your Honor's point, even if that were to happen, if someone subjects themselves to this location that has no jurisdiction and they don't successfully do whatever it is the city of Covington is asking them to do, again, while having no jurisdiction, they can then have their license revoked or suspended based on a matter that they have, based on something that they should have never been able to touch or impact. And so that's how it impacts not just me, but anybody driving through that city or anybody similarly situated. And I'm sorry, and the exact language is arrest.
Student, let me
Yes.
ask you, in the trial of your case, in the trial court, did you raise an issue about jurisdiction?
No, and in the response to that, at the time, no, it was not raised, but as the brief points out, subject matter jurisdiction cannot be waived. It can be raised at any time, including now. But at the trial court specifically and in the transcript, that is not an issue that was raised at that time. So I want to be very frank on that. It was not raised, it was not known, and it wasn't raised. It was raised here, subject matter jurisdiction for the first time, which is consistent with the law, allows that.
And that's a jurisdiction of what court?
The city court.
What about your conviction that you appeal is from circuit court?
Correct. So it initiated in, and I appreciate the question, it initiated in city court. And then once that was sustained in city court, it was appealed to the circuit court, which was appealed here. Meaning if it was never in the city court, it would have never got to the circuit court, so there would have never been a way to get it here. So if the court concludes, and again, I think this law needs to be clear, so if the court concludes, well, because it initiated in the city court and that didn't have jurisdiction, but the circuit court did and it cured it, I think that the state of Tennessee, we're going to be relying on that law because that's how it got here. And it was not raised in the circuit court, but it started in the city court, and the reason this case exists is because of the jurisdiction of the city court. And the language I was looking for, direct quote, is arrest for separate criminal offense, or in parentheses with an S, or offenses, which is punishable by incarceration and or a fine. That's the language used in the city court for not appearing to court or participating in these procedures. And then in the case here, they actually went through and to go to Your Honor's, to follow back on Your Honor's question, when the license got suspended, my driver's license got suspended, it was suspended through the city court. It's the city court in the city of Covington is what caused the license to be suspended, although the case was in the circuit court and ultimately here to the appellate court. The city of Covington was able to go back to get the license suspended. So they're not mincing that they believe this is all part of the same process as well. So the best argument it appears that opposing counsel was able to come up with is to say that they came up with a new amendment to their law in September of 2022 after my case was done. And they said that basically the argument is, well, if it's only $50 and the language is in the Tennessee Code Annotated mirrors the language of a city ordinance violation, then the city court would have jurisdiction. What they ignore is that in my case, not only did they clearly fine me $60, which offsets that argument, but again, the language I specifically read, if I'm subject to an arrest and or a fine, in addition to, even under their argument, $50, that's necessarily more than the $50 that at their best argument could have had jurisdiction. So I don't think there's a real question of whether or not it's jurisdiction. There may be an argument that you justices have as to whether or not, because it started in city court, does it cure it if it goes to circuit court and that cures it? Maybe that may be a discussion, but there's really no, in my opinion, based on the record and based on the arguments made, that there's a real question as to the fact that they do not have subject matter jurisdiction. Now, the other argument, which was never touched or addressed in its entirety, is whether or not it's just constitutionally vague. And I think that's important. I think that it was eye-opening to me that opposing counsel didn't even pretend to address the issue.
Did you raise that below?
Yes, that was raised in city court about it being constitutionally vague.
Did you raise it in the trial court?
It was not.
We're reviewing the decision of the circuit court, not.
Yes. So I don't believe it was raised. Whether it was constitutionally vague, I want to be clear. I do not believe it was raised. I'll let the transcript speak to that, but as I recall, I do not believe it was raised. I believe that what was raised, and this may help answer it. We raised that it was vague and that the language was not clear and that basically the language that provided the exception was the same language that was being relied on for the conviction. Well, but I don't know if it was framed as this is constitutionally vague. I don't believe that statement was made, but the arguments definitely was made. Yes.
Well, let's below. Did you testify?
No, did not testify.
Did you call any witnesses below?
I did not call a witness. The officer was a witness called by the city. That was the only individual who testified.
So how did you raise an issue about the statute being unconstitutionally vague? You didn't testify. You called no witnesses. And all the officer testified about was the stop. And he didn't arrest you. You were given a citation. So that's the only proof in the record that we have before us, isn't it?
So I disagree because, again, in the transcript will speak to that. And again, I want to be clear. I don't believe when the argument was made in the circuit court that the specific language was, this is constitutionally vague. And I don't believe it was said in that clearly. It was made in the city court, but again, I understand that That's separate, but just to answer your question, it was raised that specifically and bluntly in the city court. But setting that aside, the argument was raised was that the wireless, and it was read directly from the statute. So basically, the wireless to telecommunications device does not include a radio, a handheld, like a two-way device or anything functionally equivalent. So once it was entered in the evidence as an exhibit, the speaker, the argument was made to the court at the end of the proof that how in the world is this not an exception, even if it was on its face being used as a communication device? How does this not operate as the exception because it doesn't make calls or do anything of that nature, and it was an exhibit to further support that argument? But to go to the question, Judge Armstrong, you're digging at, I'm pretty sure that the language was not said at that time, and that is constitutionally vague, and this is a constitutional issue. I don't believe it was said that firmly, adding that extra language on it, but it was clearly argued, and there was no mincing words about that being the issue raised. So if that answers the question, again, whether that's an issue or that's a problem, then so be it. The record is the record. But that's how it was presented. But again, circling back to my beginning point, I don't see how there's any question that we're starting from an understanding that the city of Covington does not have any jurisdiction. And speaking specifically to the record, even when there's requests made of post filings, of judgment filings and things that we ask, at no point to this moment, even now, right as we stand, has there been anything submitted or requested to be submitted that would give jurisdiction to the city of Covington to even prosecute these cases or to suspend the license after the fact. And there's no real question that that's what happened here, and there's no real question that anybody who's either in the city of Covington or passing through the city of Covington is subject to these same violations. So if there's no other questions, I'll give opposing counsel an opportunity to speak, and I'll be back.
Good afternoon, Your Honors. My name is Rachel Witherington. May it please the court, I am the attorney for the city of Covington, and I will address the question of jurisdiction head on. First and foremost.
Well, let me ask you.
Yes, sir.
Are we in the right court? I mean, are you in the right court? This is an appeal of a conviction, criminal case. I mean, why is the Court of Appeals hearing it?
I believe, Your Honor, that there is law that says because of the nature of the citation, that it is a C misdemeanor, that they can be treated as civil matters and come to the Court of Appeals instead of the Court of Criminal Appeals.
You have a cite for the case that says that?
I would be happy to provide one for you, Your Honor. Yes, sir. The questions before this court, frankly, are moot. The citation and judgment from which this appeal stems from, the judgment has been set aside, the citation has been dismissed, it does not exist anymore. There is not an active controversy in this case, it's no longer judiciable, and it should be dismissed. But to address the exceptions to the mootness doctrine, I believe the only one that could possibly...
So, let me ask you a question
Yes, sir.
along those lines. I'm assuming that when we granted the motion to remand, our record was supplemented with everything dismissing this case at the trial court level.
I filed a motion, Your Honor. I filed a motion for the court to consider post-judgment facts included.
Right, and I'm trying to determine what's in our record that is not subject to that motion for post-judgment facts that would basically indicate or reveal that this case is resolved at the trial court level.
Your Honor, after the order was entered at the trial court level, I filed a notice of status to this court advising that the citation had been dismissed, attached a certified copy of the record, to which the court entered an order ordering the parties to enter a stipulation to dismiss the appeal, but Mr. Tooten would not.
When we remanded,
Yes, sir.
we remanded for a specific reason. To
Yes, sir.
allow the trial court to consider the Rule 60.02 motion.
Yes, sir.
Was that order, was the action of the trial court filed as a supplemental record?
Your Honor, I'm not aware if the record was supplemented in that process through the trial court. Again, I filed the notice with the court to advise that it had been dismissed, and the court entered an order advising us to stipulate to a dismissal here.
But obviously that didn't happen.
Yes, sir, it did not, or no, sir, it didn't.
So that's what I'm trying to do, is ascertain what our record reveals. Because normally when we remand for a purpose, you're going to get a supplemental record as to what the trial court did based upon that remand. Do we have that?
Your Honor, I'm not aware if the record has been supplemented by the trial court.
Okay.
To address the jurisdiction question, the City of Covington Municipal Court absolutely has subject matter jurisdiction to hear rules of the road, traffic violations that are C misdemeanors. The Tennessee Code annotated 16, get that exact site for you, Your Honor. 16-18-302 says the municipal court also possesses jurisdiction to enforce municipal law or ordinances that mirrors, substantially duplicates, or incorporates by cross-reference the language of state criminal statutes, so long as they are C misdemeanors. The City of Covington has had an ordinance adopting the rules of the road in Title 55, Chapters 8 and 10 since 1992. Over the last 30 years, of course, that ordinance has been amended and updated from time to time. It was most recently amended and updated in September of 2022. But at the time of Mr. Tooten's citation, hearing in city court, we did have that ordinance. But the question of whether or not the City of Covington had subject matter jurisdiction on this specific case, on this specific citation, to this specific party is moot because it has been set aside and dismissed.
How do we know that?
Your Honor, I think you would know that if in my motion to consider post-judgment facts, that is included.
I understand that that's the subject of your post-judgment, for a request for us to consider post-judgment facts. But if we don't do that, how do we know that?
I think Mr. Tooten just admitted to the court that it had been dismissed.
Okay, we'll ask Mr. Tooten that when he gets back up here. But
Go ahead.
I'm just trying to make sure that our record is as our record's supposed to be.
Yes, sir.
Go ahead.
And did Mr. Tooten file a supplemental response to your motion to consider post-judgment facts where he agreed to our consideration of those post-judgment facts?
Yes, sir, he did.
Okay, all right.
And Your Honors, back to the exceptions that would constitute circumstances for the mootness doctrine not to apply here. I don't believe any of the other ones, with the exception of the public importance, would apply. And I've demonstrated in the brief that I filed that state law confers this jurisdiction on municipal courts to hear traffic citations. We have an ordinance adopting the rules of the road. That's a simple question. We do have subject matter jurisdiction to hear those. Judge Armstrong, you asked the question, is there evidence in the record that the city is simultaneously prosecuting people without jurisdiction? No, there's not any evidence in the record because that's not occurring here. As far as Mr. Tooten's driver's license being suspended, I addressed that in a notice to the court. There was a delay in getting the order entered in the lower court. I can offer you explanations as to why that happened, but excuses are irrelevant. That was my fault. It was an oversight on my fault. The minute that Mr. Tooten notified me that his license was suspended, I tracked down Judge Neal, who was our trial court judge who replaced Judge Walker. I got the order entered the same day, which was October 31st. Or November the 1st, I contacted the Department of Safety and said, this citation has been dismissed. This suspension was done in error. Please reinstate his driver's license, which I notified Mr. Tooten. I took those actions. And according to the information provided to me by the Department of Safety, his license was reinstated that day. Absolutely, there was no intention by the city of Covington whatsoever for the license to be suspended. I can speculate on how that may have happened, but I can say certainly that no person from the city of Covington directly engaged the Department of Safety to suspend his license, and absolutely the delay in getting the order entered at trial court was not with the intention that his license would be suspended at some point. That was certainly an unfortunate mistake, and I remedied that as quickly as I could. But some of the argument that Mr. Tooten wants to make in his arguments to the court and in his brief is that this settlement agreement that we reached was breached, and he has suffered these other damages. If he believes that to be true, then that's a cause for a trial court, for there to be evidence presented, facts found. It's not properly before this court to make that argument at all. So, to conclude, Your Honors, the bottom line in this case is that there is no existing controversy. There's no relief for this court to grant Mr. Tooten because the relief he requested in his appeal has already been granted, and I believe the case has been resolved. Mr. Tooten has made arguments to the court that I am making misrepresentations to this court by saying that the case has been resolved. In my opinion, it has. The facts speak for themselves. I believe the legal issues are resolved. The appeal is moot and the case should be dismissed. So respectfully, Your Honor, I would request that our motion to consider post-judgment facts and to dismiss the appeal be granted. If nobody has any other questions, that's all I have.
Thank you.
Thank you.
One question. Are you related to Sid Witherington?
Your Honor, I used to be by marriage, but not anymore.
Okay, all right.
He was a doctor in our county for a long time.
Okay.
So, again, to address the point that, Your Honor, Judge Armstrong, you made, and it was a very good point, is the proper court? I agree it was a criminal matter and it should have never been in the city of Covington. Now, the argument opposing counsel just made about whether there's the TCA that allows for this mirroring of jurisdiction is one of the arguments I addressed the first time. Please review it. It specifically talks about if the maximum punishment is $50 or less. I'm surprised that didn't come up in this past argument. It has to be limited to $50 or less and be mirroring of the traffic violation. Here, even under their own record, they said that the fine for me was $60, which is presumably the fine they're doing for everybody. And as I read the direct language, if I failed to appear, I would be subject to arrest for a separate criminal, Your Honor pointed that out, offense, which is punishable by incarceration and or a fine. That has not been refuted. I'm not making this language up. This is the language they use that went unrefuted. So in one breath, you can't have this language under these laws and then turn around and say, so there's no harm. So now that circles back to the other issue that was being raised.
Let me stop you just
Yes.
a minute, Mr. Tooten. Do you agree that upon remand, the trial court granted the Rule 60.02 motion?
Yes, and I was just about to go to that point, and that goes back to the other issue that was raised. If Your Honors don't believe that this is a matter that would affect anybody other than me or does not impact anybody else or that this is limited or isolated, then I would make it easier. I don't believe that any of the exceptions would apply either. I believe what makes the exceptions apply is that there's nothing in the record suggesting that they have stopped doing this or that they're not doing this. Everything in fact, everything is the indication that they're continuing to do this. So again, if the concern is, well, a jurisdiction is cured once it goes to circuit court, so be it. If the concern is it's limited to just Mr. Tooten, so be it. But I don't believe that to be the case, and the record is clear. And then just briefly, I'll go through the time periods because there's language about immediately resolving the matter. On August 16, 2022, updated this court that I was informed that this matter would be resolved by the end of that week. August 22nd, 2022, I follow up with the city, nothing. August 29th, 2022, I offer a proposed order submitted to the city to get it done, nothing. Then on September 13th, apparently 2022, the city of Covington sends my information to the Department of Safety, which causes my license to get suspended ultimately. But in between that time, me not knowing it, October 8th, 2022, follow up, nothing. Then on October 13th, 2022, the city of Covington is able to somehow reclaim jurisdiction and suspend my license. So again, if the belief is it's unique to me, I don't believe there is any controversy. But based on what I'm seeing, it does not appear unique to me. This appears to be an issue for anyone.
Mr. Tooten.
In your supplemental response, you did ask us to consider the motion post-judgment facts.
Yes, I have no problem with that. I don't want to hide anything. And I will agree that that stuff happened as far as the order.
Right.
Mr. Tooten, do you agree at this point that the judgment has been dismissed by the court?
I
against
agree
you?
that the judgment has been dismissed and that my license is at this point no longer currently suspended. I'm agreeing to all of that. Whether it's properly in the record or not, I'm telling you as an officer of the court, those things did in fact happen.
Thank you.
Thank you. Thank you, counsel. We appreciate your argument, your briefs. We'll take this matter under advisement and we'll render an opinion at the earliest possible time. Judge Morgan, good to see you back there in the back of the courtroom.
I just want to go check on him.
Smiling like a Cheshire cat.
I had no idea Mr. Tooten was here, but it's always good to see him, too.
Yeah, well, it's just like old